All right, good morning, everyone. This is a small crowd today, but we're really glad that everyone here has joined us to learn about the Parole in Place program. Before we begin, I just want to let you know that this event is being filmed for those who can't attend here today. However, the voices are of people in the audience are not going to get picked up by the recording, and the recording is going to focus on the front here as well. So just wanted to give everyone a heads up about that in the audience. My name is Erin Schutte-Wadzinski. I am an immigration attorney and the owner of Kivu Immigration Law, and I'm joined here by two of my colleagues who will briefly introduce themselves.
Yes, hi everybody. Thank you so much for being here today. My name is Cece Lopez Diaz Jensen. I'm a recent graduate from the University of Miami School of Law, and I'm also a current legal fellow with Kivu Law, and will be here in Worthington assisting you all moving forward.
Hi everyone, my name is Kendra Jean. I'm a legal assistant with Kivu Immigration Law, and I also interpret English, Spanish, and Haitian Creole.
So we're going to provide some basic information that is helpful for all of you to know today, but there will be time at the end for specific questions and answers. We don't encourage case-specific questions in this type of forum, but we are happy to speak with you afterwards if there's anything specific or personal to you that you would like to discuss. So first of all, I want to provide a brief overview of the existing U.S. immigration system and how it relates to family-based petitions. So currently, the U.S. immigration system allows U.S. citizens to petition their spouse and children for permanent residency in the United States. However, under the current immigration system, the spouse or child must either be living outside the United States for that process to be successful, or the spouse or child must have lawfully entered the United States, such as on a visa, for example. For those family members who live in the U.S. and their last entry to the United States was not lawful, the immigration system requires that the family member returns to their home country for their family-based permanent residency interview. This sometimes includes a waiver application, carries risks of being stuck outside the United States, and takes many years to complete. That problem of family members having to go outside the United States in order to get permanent residency is what this new Parole in Place program aims to solve. So, a new program last week rolled out by the Biden administration called Parole in Place makes it easier for spouses and children of U.S. citizens who entered the United States unlawfully to have a straight and faster path to permanent residency without having to leave the United States. This program, Parole in Place, does not change eligibility requirements for permanent residency. It just makes the process easier and faster for spouses and children of U.S. citizens. Families who've already started the family-based petition process and families who already have filed a family petition or a spouse petition, or maybe even a waiver application, and are facing long processing times should really consider this program, because those are the families who are going to be impacted most directly by this new program. Everyone whose Parole in Place application is approved may immediately apply for employment authorization and a Social Security card. So, this type of benefit, so an EAD, a work permit, and a Social Security card, is typically not something that is afforded to spouses or children while they wait for their application to process. But one of the big benefits of Parole in Place is that those who obtain Parole in Place can immediately apply for employment authorization and that Social Security card. The work permit or the employment authorization card will be good for 3 years. Right now, the government is not indicating that it would be renewable after those 3 years, but rather saying that it's going to be good for 3 years because those who are eligible to apply for permanent residency should be able to become permanent residents within that 3-year period. So let's talk about who specifically is eligible for Parole in Place. Spouses of U.S. citizens are eligible for Parole in Place if they are present in the United States without a lawful entry, if they are able to demonstrate that they entered the U.S. on or before June 17th, 2014, and have not left the country since then. You might be thinking about, what about that random date, June 17th, 2014? Well, that is 10 years before this program was announced by the Biden administration. So the way that this program was created is that, well, individuals have to qualify must have been in the United States for 10 years as of the date that the program was announced. That's the significance of June 17th, 2014. In addition, spouses of U.S. citizens must be married, well, obviously, married to a U.S. citizen since on or before June 17th, 2024, the date the program was announced, and still be married today. There are exceptions to a current marriage if the U.S. citizen's spouse is deceased. In addition, to qualify for parole in place, the spouse must have no felony convictions or other serious criminal convictions. This is not the U.S. citizen, but rather the applicant applying for parole in place. Children and stepchildren of U.S. citizens are also eligible to apply for parole in place if they arrived to the United States by June 17th, 2024, without lawful entry. So unlike spouses, children are not subject to that 10 years of continuous presence. In addition, children and stepchildren must have a U.S. citizen biological parent, or stepchildren must have a biological parent who is married to a U.S. citizen as of June 17th, 2024. Children and stepchildren of U.S. citizens must be under 21 and unmarried in order to qualify for parole in place. However, there's one exception. If an I-130 family petition was filed by the U.S. citizen step-parent when the child was under 21 and unmarried, but is now over 21, that application filed earlier freezes the age of the child or stepchild, and the child remains eligible for parole in place even if they're over 21 now. It's just that that family petition had to have been filed before the child turned 21. I want to make a special note that individuals who are currently in removal proceedings or immigration court may still apply for parole in place. So just because you've had contact with immigration or have to go to immigration court does not disqualify you automatically for parole in place. However, there are some restrictions on who can apply. So let's talk about who is not eligible for parole in place. You're not eligible to apply for parole in place if you are not the spouse, child, or stepchild of a U.S. citizen. You're not eligible to apply if you last entered the United States through admission or parole. So if you got a stamp to enter the United States in your passport, that's likely considered an admission or a parole. And then you don't need parole in place in order to be able to apply for permanent residency here in the U.S. without leaving the country. So just to be clear, you'll hear things talk about, well, if you have admission or parole, you're not eligible. But I want to make sure that everyone understands what is admission and what is parole. So admission is the term that immigration uses if you entered on a visa or a border crossing card. Parole is if you entered the United States on humanitarian parole, TPS, advanced parole, or DACA, advanced parole, and there might be some other types of parole out there, but those are the most common types. For applicants who entered on one of these statuses, you don't need parole in place, so it's not necessary for you to apply. You're also not eligible for parole in place if your last arrival date to the U.S. was less than 10 years ago. You're not eligible if your marriage to a U.S. citizen occurred after June 17th of this year, Or if you're married to a lawful permanent resident who later becomes a U.S. citizen, they have to have been a U.S. citizen by June 17th of this year. If the applicant has a felony conviction or other serious criminal history, the application will be denied. If the applicant has pending criminal proceedings, even if they're minor, the applicant must wait for those criminal proceedings to wrap up and for there to be a final answer before you can submit your application for parole in place. Okay, so that's some general information, and I'm going to pass the mic to my colleague Cece to provide further details.
Thank you so much, Erin. So we're also going to cover a little bit about what evidence you would be able or would have to submit in order to sort of support your application. I do want to distinguish between the people who are applying as spouses to U.S. citizens. That's a little bit different than those who are applying as either a child of a U.S. citizen or a stepchild of a U.S. citizen. If you're applying as somebody who has a U.S. citizen spouse, you would have to prove a 10-year period of being here in the United States. And you would be able to prove that through a number of ways. Ideally, you would, one, have a proof of identity, as well as a marriage certificate to sort of prove your marriage to your U.S. citizen spouse. In addition to that, again, you would have to prove that you have been here for 10 years. The way that you would do that is providing rent mortgage statements, for example, bank statements, utility statements as well, and a number of other documents. This can also include school records, employment records, church records, money records, car payments, insurance documents, medical records, and memberships to any sort of gym or anything like that that would prove that you've been here for the period of those 10 years. Now, those who are children or stepchildren to United States citizen spouse or parents, rather, they do not have to prove that. They just have had to be in here since June of 2024 of this year. It's also important to note that the government will be conducting a background search, FBI background search, to determine both your immigration history as well as any criminal history. So it's really, really important that if you do have a prior record, that you provide all available records that are in your possession, as well as certified records if you are able to get that. Now, another thing that we do want to discuss, and you may have heard at this point, is that there is an ongoing lawsuit that has come about this week that has sort of tried to stop the Parole in Place program. Now, what has happened is that a lawsuit has been filed in Texas and a temporary injunction has been put in place. What that means is that for the next 14 days, the parole in place applications themselves are not going to be approved. So the courts have kind of paused on that. However, they are still accepting those applications. And so while we don't know necessarily the exact future of where the program is going at this point in time, and we cannot guarantee what the outcome is going to look like, we do encourage individuals to go ahead and submit their applications, because if they do resume the approvals, then your application will be processed a lot faster. So it's important to keep that in mind, especially as more folks are talking about what the future of the program is going to look like. The other thing is just the application process itself. Now, what does it look like to actually submit the application? The application itself is strictly online. It is not something that would be submitted via mail or on paper. The process is ultimately created so that individuals on their own can go ahead and submit that on USCIS. You would create an online USCIS account if you don't already have one, and you would submit what's called a I-130F form through that online application. Ideally, you would, along with all the other documents that we covered, you would submit an essay to sort of describe why you believe that you sort of deserve to go ahead and receive that parole. I do want to mention that this is a discretionary application, which means that USCIS is going to look at your overall immigration story, or just your story overall, to see whether you're a good contributing citizen, etc., and as somebody who would sort of merit parole in place. And this is sort of what the essay would be to help justify that. Again, you would upload all those supporting documents and then also electronically sign your application. The total fee for the application itself is $580. And then I believe I'm going to pass it on to my colleague Kendra, who's going to cover the remaining.
Okay. Qualification to adjust status. If a person has an approved parole in place application, this is a straight pathway to have a permanent residency. However, not all people having the parole in place approved will be eligible to adjust status in the United States. Applicant with for permanent residency will not qualify if they have ever made false claim to U.S. citizen, if they have used U.S. citizen documents, if they have any criminal history, felonies. Um, if you ever have a criminal history, we recommend you to discuss with a trusted attorney. However, notarios are considered like legal professional in many countries. In the US, they are not accepted as legal professional. So if you want someone to represent you, it should be an attorney or an accredited representative. USCIS will never accept money transfers from Western Union, MoneyGram, or PayPal. They will never ask you to give the fee to a person. So if these are some recommendation from someone who is filing an application for you, you should avoid it because it's considered fraudulent activities. Um, with Kivu, we offer legal representation. We will help manage your application from start to finish. So in the process, we will help you with the first step. First step will be scheduling an initial consultation with us. We charge $150 and they should be paid the day of your initial consult. We have opening for the month of September, and if you choose Kivula to represent you after the initial consultation, we charge $2,000, from which $1,000 will be received the day you sign your contract with us, which is a representation agreement, and the other $1,000 will be paid before we file your application. Even the program is on pause, we still can submit the application. However, if they cancel that Parole in Place program, we will not be able to issue a refund.
And then just one last thought as well. Some of you may be thinking, what are the risks of actually submitting this application? And is this something that I really want to undertake? There are sort of three broad categories of individuals who may want to consider the risk involved with submitting this application. Those who have the greatest amount of risk are applicants with prior orders of removal or have previously unlawfully re-entered the United States. This is the riskiest scenario, again, because you are potentially at risk of removal, especially if you have an unexecuted order of removal or if you apply and have a criminal history that may bar you or prevent you from being approved. That just would notify DHS at that point that you may potentially be removable. Now, those who are at medium risk are applicants who have never filed an application. If you have never had contact with USCIS or immigration before, just note that if you do submit this application, at this point, they would have noticed that you are present in the United States and would have your details at that point. And that is something that you would just have to consider whether that is something that you would want to undertake. Those who are at the least amount of risk are applicants that are already in removal proceedings or deportation proceedings and have filed prior applications. Because at that point, the government already knows that you are here, already knows that you are present, and has your information readily available. What does that mean for those who are at least risk is that there's really no harm in applying. It means that, again, they have your information and you might as well try to attempt it, especially if you are a qualifying applicant.
So, the timing of this information session coincides with this lawsuit down in Texas being ever developing. And our office is monitoring that lawsuit carefully and relying on experts who are also following the lawsuit. those who are closely following that lawsuit and have been involved in these sorts of court battles for many, many years are still encouraging applicants to submit applications. Now, some people want to wait to file anything because they don't want to spend any money for a program that could potentially, worst case scenario, be shut down. But we also want applicants who qualify to have the best chance possible of getting parole in place. And so continuing to submit applications demonstrates how important this program is. And the earlier you apply, the earlier your application will be processed if and when the program is back up and running. So there is uncertainty. Our Kivu immigration law Facebook page will stay up to date on the status of this lawsuit and the parole in place program. So if you don't already follow Kivu immigration law on Facebook or Instagram, I encourage you to do that if you want to stay up to date on this program. So this info session, we're concluding the English version of this at this time. At 11:30, we will begin the same info session in Spanish. We will cover the same information, but it will be communicated entirely in Spanish. But before we begin that, we may have time for a few questions from the audience if anyone has them. I'll just remind people that who are in the audience that this information session is being filmed. The cameras are only on the three of us, and we don't anticipate that voices in the audience are going to be picked up on camera. But I will kind of summarize whatever questions are asked and then answer them at that time. Are there any questions? Erin, do you have any idea how many people this could impact in our community?
Or not community. So nationwide, it's 700,000?
500,000.
Okay.
So nationwide, the government predicts that this program could impact 500,000 spouses and 50,000 children and stepchildren. What percentage of those live in southwestern Minnesota is hard to tell, but we do know that this program has potential to have profound impact in our community. Yes.
Can you get an estimate time when the program's going to be go back and run again, please, as it's possible now?
So the question is there an estimate for when the program will be back up and running again? Right now, all we know is that there's a 14-day pause. And that pause began on Monday of this week. So we're looking at mid-September at the earliest before the program would be back up and running. But in mid-September, what we'll be looking for is an update from the court on how they plan to proceed with the lawsuit. So the best case scenario is that in mid-September, the lawsuit is thrown out and the program can run as it intended to run. But there are other scenarios and things could continue to be on pause until the court sorts things out.